Porter.
Thank you. Good morning or good afternoon, as the case may be, and welcome to our Mass Torts Litigation webinar, which is the fourth in our series on mass torts, and it's the final in the series. If you were not able to attend any of the earlier ones and would like to do so, or at least to view them, feel free to go to our website at www.arnoldporter.com. And if you click on our practice and select product liability litigation, you'll be able to find those prior sessions in the events category. Just a couple of mechanical issues. For today's webinar, the lines have been muted, but if you ever need assistance during the call, just press *0 on your phone and the conference coordinator will be able to help you. Also, we have a chat feature, as many of you may know, in the WebEx program, which allows you to ask questions during the program. If you want to send us a question, we will be viewing it here, and while time constraints might make it impossible for us to answer all of the questions, we'll certainly try to answer what we can. And of course, feel free to contact us after the program if you want to follow up on any other questions. Finally, this event is being recorded and will be posted on our Arnold and Porter website, where it'll be available for public viewing afterwards. And shortly after the program, we'll send you a short link with an evaluation form and presentation materials from today, so you'll have those for yourselves. With that, let's get started. First, let me make some introductions for our panelists. We're actually coming to you bi-coastally today, but from our New York office and from our San Francisco office. In San Francisco, we're joined by Judge Richard Kramer, who is a judge of the San Francisco Superior Court, who was appointed there by Governor Pete Wilson in December of 1996. He presided over felony trials for 5 years and then joined the General Civil Trial Department. Most notably, from about 2002 until just the beginning of this year, Judge Kramer was assigned to the San Francisco Superior Court Complex Litigation Department, where I think it's safe to say he was renowned for his effective management of innumerable complex cases, including many, many mass torts. He also served as a justice in the Appellate Division of the Superior Court for 3 years and as a justice pro tem in the Court of Appeal. And he's also an adjunct professor of law at the University of California, Hastings College of Law, just with all the extra spare time he must have. But we welcome Judge Kramer today. With Judge Kramer in San Francisco is my partner, Matt Hartney, who's actually from the Los Angeles office. And Matt has a long experience in a variety of cases, including many, many mass torts. He's involved in lawsuits and regulatory proceedings involving as well antitrust, environmental cases, RICO, products liability, and federal securities laws. And now here in New York, I'm joined here by Bill Voth, my partner. Bill is also a very experienced product liability lawyer and has a long experience with mass torts, consumer and product liability litigation involving a whole variety of things, including medical monitoring claims, class actions, government cost recovery suits, and the like. And I am actually from the Washington, D.C. office and am a trial lawyer and mass torts lawyer myself, primarily involved in litigating pharmaceutical mass torts. Unfortunately, Jen Dubas, who was on our program, who was from Endo Pharmaceuticals, is not able to join us today due to some pressing business matters, and we're sorry she could not join us today. We thought we'd start by focusing today on primarily on some of the ways that mass torts can be brought to a successful conclusion other than by settlement. And that is, we'll be talking about some of the strategies and techniques that can be used to get to or achieve what we call the endgame. And for purposes of today's discussion, we're going to use the term mass torts to mean both, single events with many victims, like an explosion, for example, and mass exposure events. That is, for example, where drugs or chemicals have been, or people have been exposed to drugs or chemicals, often for long periods of time. So we're going to be talking about mass torts in both senses. And as I'm sure all of you know, mass torts present unique challenges for a variety of reasons, unlike many other cases. We'll just touch on those quickly. Obviously, just the size of mass torts. They're mass torts for a reason. They're large. There are many plaintiffs involved, and they typically involve the extraordinary amount of expense and time. Obviously, the number of parties involved are often a challenge in themselves, especially when you have parties from approaching the issue from different perspectives. For example, you might have manufacturers, you might have distributors, you might have, in a pharmaceutical case, doctors. On the plaintiff side, you may have a variety of different classes or types of plaintiffs. The discovery is often extremely broad and wide-ranging, often multinational. Mass torts also present unique problems involving collateral estoppel and res judicata issues, especially for defendants. And so those are issues that you have to keep your eye on, obviously. Mass torts are also complicated by the fact that you frequently have multiple counsel representing all these different parties, many of whom will have separate interests and maybe competing interests, especially often on the plaintiff's side. Also, of course, you have cases where you're dealing with many different jurisdictions and courts, state courts, federal courts, multiple jurisdictions overlapping in many cases, and obviously that presents certain challenges as well. And then just the sheer ability to manage the cases and keep them moving it presents its own unique challenges. And as far as that goes, I'd sort of like to start with a judicial perspective, Judge Kramer, as a trial judge who's presided over many mass tort cases. What particular challenges do you see in mass torts from your seat on the bench?
Well, the subtitle of this program is All's Well That Ends Well, and I'm actually participating in a slightly different webinar than the rest of you gentlemen here. The title or the subtitle of my program is called All's Well That Ends, period. And the point of all that is that from a judicial perspective, the most important characteristic of mass torts, be it the kind where a single event has allegedly harmed a bunch of people, or recurring events of a similar nature allegedly harmed a bunch of people, is case management. Case management is the most important focus from a judicial perspective. And there are many reasons for that. The first and perhaps most important is that, as you all know from reading your newspapers, judicial resources are getting scarcer and scarcer. And if we're basically called upon to do the same thing many times, it doesn't take long to figure out we better be able to save judicial resources by being efficient in how we cause the same thing to be resolved many times. And that is certainly true when all of the mass tort claims, be they separate cases or not, are in the same court. In California, for example, we have what's called a judicial coordination proceeding, where a bunch of cases get put together, individual cases, but they are assigned singly to one judge. They span multiple counties. Sometimes there's thousands of them. I have some right now with thousands of cases. And if we don't figure out what to do about these things, we are choked. You add to that the point that was made a minute ago, which is that we often have multiple jurisdictions. The easiest one to deal with, but it's still quite the administrative challenge, is where you have a federal MDL and state court coordinated proceedings. The federal to state coordination is a hot topic these days for whether to do it, if so, how to do it. Nobody asks why to do it. but the idea is to coordinate with a different jurisdictional system and to try to avoid the problems of case administration. Yet harder, but still possible and still occurring, is where you have either two separate states or multiple separate states, or better yet, federal and multiple state cases. And the whole idea there is to coordinate it and to make it end. Now, why make it end? Well, I said judicial resources is important. The focus is normally at the trial court, but many of these cases involve things that are going to go to a court of appeal, either on an interim basis or at the end. And one of the objects is to focus appellate resources so that appellate courts aren't doing the same things over and over again. And under the California rule regarding coordinated cases, we actually designate a single appellate district to hear all appellate work that come out of these cases, no matter where they originated. In the federal system, it's a little bit more complex under the MDL rules, but at a minimum, you've got two appellate courts working when you're coordinating with federal and state. Well, the point is simply to avoid duplication. The other reasons for coordinating these unique cases is, yes, we care about you and your clients and plaintiffs. To the extent there are plaintiffs on the phone here, we care about plaintiffs' counsel too. Your resources are scarce, and we don't see any reason to duplicate your costs and your efforts. And that starts with setting the cases up for what's going to happen, continues through discovery, and discovery, as you know, is getting more and more expensive, proceeds to court hearings, and ends up with trials and appellate work. So the resources of the litigants are something important. The bottom line on all that is we work for the government and we're here to help you. Usually we get raucous laughter when I say things like that. Another reason for coordinating is avoiding inconsistent results. Major problem with mass torts. Now, when you guys think about this, you're just thinking about winning or losing, and you're thinking about inconsistent results regarding who won, who lost, how many cases did I beat, how many cases did they beat me, and the like. But it's more serious than that from a judicial perspective, because often we are called upon to deal with questions of science, questions of causation, which may not involve science, and just about anything you can think of. And the problem here is that when you're trying to coordinate these cases, and one of these could be determinative questions as to what went on in the real world occurs, it would be nice if there was a consistent ruling as to whether or not this drug causes this problem, as to whether or not the defendant was responsible for leaving the nitroglycerin on the table that blew up half a city, and the like. And the way it works, of course, with preclusive effective judgments, if you have a single or a small group of defendants and separate plaintiffs, a determination as to against a defendant will almost certainly bind it going forward in other cases, whereas the converse is not true, that you could continue to try these cases as to, say, a scientific determination, and plaintiff number one could lose, plaintiff number two could lose, etc., until you get to plaintiff number 12, and plaintiff number 12 wins, and then that might be the rule, whether or not the determination has anything to do with what happens in the real world. So the idea of avoiding inconsistent results is an important one. I know that we're not going to be talking about settlement, but the point of effective administration is to hopefully allow the invisible hand to show up. And therefore, effective administration tries to get to the heart of what's going on with these cases and see if you can't determine something that will make everybody sit down and have rational business people make rational business decisions. It might be a determination of a scientific question, might be a question of causation. It might be a determination of what might be a representative amount of damages. Could be just about anything you could think of that the parties consider effective for analyzing a bunch of cases. So in case management, that is what we look for. The concept that you hear all the time is a bellwether case. I have to admit to you, when I first heard the term bellwether, I envisioned a lighthouse shining a beacon so that all the little ships at sea caught in the fog could get to the end without crashing into the rocks. Turns out, and I'm sure all of you are very well-educated people, a bellwether is actually a neutered ram. Wether, W-E-T-H-E-R, is a ram, and the neutered ram is to herd sheep, and it's neutered for obvious reasons. It works herding because the sheep don't know it's neutered, and they put a bell around its neck, and the rest of the sheep follow it around, and the bell is so that the shepherd can figure out where they're going. So the next time you people with your huge sophistication talk about picking bellwether cases, remember it's not just a metaphor, it's a literal meaning of what that means. But the bottom line is that from my perspective, this program, the best thing I can tell you is how we administer these things.
So, Judge, what kind of case management techniques or plans have you found especially effective for corralling these behemoths and especially for positioning them to get resolved?
Step one, in my view, is always, if you spot cases that you have that look like they could be recurring elsewhere, is to get a full roll call of what exists where. And if they are within my jurisdiction, then to use the procedures for bringing cases in other counties to San Francisco, or better yet, sending all my cases somewhere else, so that they all are in one place. If there is a MDL or even individual federal cases, the process is exactly the same. You figure out where they are, and you figure out not how to get them in front of me, but how to coordinate. And here comes the shocker. We call other judges. Federal judges call me, I call federal judges. A lot of you have fallen off your chairs. Go back on your chairs. We do not talk about the substance of the cases. We certainly don't discuss your personalities, although there are occasions where we would love to do so. But we talk about the existence of the cases. The next thing we do is figure out if we're going to coordinate, and that is usually a no-brainer unless for some reason the nature of the cases or the nature of the judge would make it inappropriate or difficult to do so. Such things as you don't find out about the other cases until they're all just about ready for trial, but you're just starting out. Tough to coordinate. But by and large, the earlier you do this, the more likely you're going to get them. So you make a list of the things that you can coordinate, and you start with the obvious ones, such as discovery. And then you move to the more difficult ones, such as sequencing events, so that you people are all basically doing similar things at the same time. Maybe even coordinating the resolution of certain issues. Not that the judges will all do the same thing, but rather we could have, for example, what we call scientific hearings, where the judges get together, we sit on the bench together. They almost always come to San Francisco, by the way, so we usually do it in my courtroom. And you guys bring a bunch of geeks in and educate the judges on technology or terminology or something like that. You can do a similar thing with joint hearings to resolve issues. You can have a giant product identification or causation or some other science thing where literally you've got two judges sitting on the bench, you've got a mass of lawyers sitting out there presenting the same evidence or slightly different evidence depending on what the legal rules are in the jurisdictions. And then the judges go off, no, we do not talk to each other, and you render your opinions. It has happened, by the way, not to me, but I know of instances where the two judges came to the exact opposite conclusion regarding a physical occurrence in the real world. But, I mean, that's going to happen perhaps anyway. I think more likely you at least get the same evidence and a coordination of matters so that appellate courts can review the ultimate decisions. And then the last thing that I'll say about a technique is sequencing trials. If the situation is where there's many, many individual cases as opposed to a giant group of plaintiffs, and if you're going to utilize this bellwether thing I talked about, you sequence trials. First, to get the most bang for the buck. Second, and here's another one of these, I work for the government, I'm here to help you things, that the lawyers aren't having competing appointments with courts. I've got one now with a medical device where we're alternating the state court and the MDO. We're alternating trying bellwether cases. And ultimately, and I hope relatively soon, the pattern will develop that will satisfy the litigants. But we're not killing the lawyers, which is what we're trying to do here. Those are basic tools we use.
Thank you. Obviously, a significant way these cases can be brought to an end is through effective legal arguments and motions practice before trial. And Matt Hartney is going to lead a discussion on that topic.
So thank you, Steve, very much. To start us off, particularly in a complex matter such as a mass tort, where the objective is to develop a plan for some case ending or case limiting legal arguments, I think it's very important to start with developing a plan. And this is true not only because it's a good idea in itself, but as Judge Kramer has been discussing, it's not going to happen these days that if you're in front of a complex court, whether it's federal or state, that they are going to just sit back and let the lawyers decide to bring motions whenever they want. These are going to be coordinated and they're going to be sequenced, and a lot of thought is going to go into in the judge's mind and in the discussions the judge has with the parties as to what's going to happen. So in order to participate effectively in those discussions, you need to have thought through what your objectives are and how you want to present these motions and the like, what are the things that have to happen before you're going to be ready to do that. So one early step in this, we're talking about the end game here, that's the purpose of the discussion, but you're not going to get to that end game with case limiting or case ending legal arguments unless you've done quite a lot of investment of time and work up front. And so one key thing, if you are when you are sitting down with this behemoth of a case and trying to decide legal arguments that you might want to bring, is to identify what your best targets are. Identify where you can come up with results that are going to matter. And I'm sure this is apparent to everyone on the call, but I've just observed many times that if the idea is to bring yet another preemption motion or yet another preliminary or primary jurisdiction motion, if that's just being brought because it's a possible motion and we want to try everything we can to kill the case off, not likely to be effective. You need to pick your motions with a very intense focus on the case and what really works for the case, where there are facts that in the case that are going to make this kind of thing compelling. And judges are not going to react well to throw everything up against the wall and see what'll stick. So how do you do this? Well, one thing obviously is you're going to have fundamental case themes. Sometimes legal arguments fall out of that. Another, and this is one that I think is very important and worth thinking about, virtually, and I'm speaking here as a defense lawyer, but virtually every plaintiff's case I've ever seen has areas where the plaintiffs are trying to make life easy for themselves. They're trying little shortcuts, or they're proposing something new. And we'll talk about a case study of where this was happening a little later in some climate change litigation. But if you can identify places where the plaintiffs are, they're trying to do these things, it's very fruitful to really dig into those, look at them very intensely, and find out where you can point to legal flaws or challenges in what they're doing. And then finally, it's always worth looking to where does the plaintiff's case, if carried to its logical conclusion, create burdens or problems for the courts, for regulators, or or the public itself, and that's a fruitful area to look at. Once you've got a target selected, I think. Obviously, every good lawyer knows it's very important to work hard to develop, and prepare for these sorts of things. But I'd like to just mention a characteristic that I've seen over the time, and I think most lawyers have seen to some extent, and that is that if you bring a strong motion, the most likely outcome, in my judgment, that you're going to see is that your opponent is going to try to change their theory of the case in a way that will sidestep that, or that will make it easier to respond to your motion. And very often, if you've thought of what you want to do, if you thought of the theory that you want to attack and how you're going to attack it, you can employ discovery in advance so as to pin them down to an early position and think through where they're likely to go if a motion comes up, and try to close that off. You can try to do that through interrogatories or written discovery, like requests for admissions. But frankly, those often get written in a way that, if a lawyer's writing the responses, you're not going to get much of anything but mush. So if you can get a Rule 30b-6 or person most qualified deponent, and get them on in the chair, and in a position where you can ask them questions about what facts they're relying on, what's the basis for various positions that they're taking, and to close off other areas, that can be an incredibly valuable way to set up motions that can be successful later on, because the alternatives have been closed off. In the interest of time, I'm going to jump ahead a little bit here, but I will say also, as a key learning that I've at least found over the years, is that if you have an idea and it's a good one, but something comes up and it doesn't win, think of another way to repackage it, because almost any fundamental case issue can be raised in multiple ways and in different flavors that will have a different potential, give you multiple ways to try to make your point and make it successful. Well, let's jump ahead and talk about an example, kind of a case study, and causation is almost always a promising target. Judge Kramer mentioned that, and the way the importance that it can have. The acclaimed treatise Keaton and Prosser on torts, says pretty bluntly that causation is essentially an essential element for almost any tort, and so it's always a good thing to look at. And fundamentally, it's just how are they going to connect? How are the plaintiffs going to connect their injury to the defendant's conduct in a way that's sufficiently close to justify relief? A lot of times the people in a case where there are injuries, real injuries to plaintiffs, and there's conduct that has led to harm. The lawyers on the other side may want to change their case to focus on higher value, deep pocket targets where there's a lot more money that they might be able to extract, rather than parties that may be more directly connected to the harm. And then you start to have, again, they're trying to make life easy for themselves. They're trying to innovate. There are challenges. They're creating challenges for themselves, and that's an area where you can look at. Product liability and tracing, they really have got to bring your product to the plaintiff. They're just not going to be able to link up, your particular defendant with that harm. And there are theories that have come up, and they're very frequently used in some areas. Market share, a new theory that came out of the Southern District of New York called commingled product theory, in which if there's products get mingled together and can't be identified, then it's kind of like market share, although it doesn't have the same doctrinal basis. There's a lot of law that still has to be developed there as to when a party can be excused from proof of product liability, but it's a very, very fundamental point that is worth looking at. Skipping down, in the interest of time, another key situation is where you have multiple causal factors of which the defendant's conduct is only one that could lead to this harm. And this came up in the Supreme Court's recent Comcast decision in class certification, where the court essentially found that the common proof that the plaintiffs needed to have to show their damages failed because the proof recognized that there could be multiple causal factors that cause this, of which the defendant's wrongdoing was only one, and said if there are multiple possible causes and you haven't eliminated the other causes as creating the harm that you're trying to seek recovery from, you haven't made the link. You haven't established the causation that you need to do. So let's talk about a specific example. I think an interesting one that I was involved in, along with many, many other lawyers. And this is climate change, which is something that a lot of people are interested in. And this case was put together by the Sussman Godry firm and a group of firms trying to really find where was the ideal plaintiff to bring a climate change nuisance case. And so they picked a native Inupiat village on the west coast of Alaska on the Chukchi Sea, and that village alleged that it was being harmed because the sea ice that would develop in the wintertime and protect them from winter storms was disappearing due to global warming. We'll show you a picture in a minute or two, and you'll be able to see the physical phenomenon they were talking about. And so they brought a lawsuit against selected oil, utility, and coal defendants, saying that they contributed to climate change by their greenhouse gas emissions. And they said that these defendants that they had picked are responsible for a substantial portion of the global greenhouse gas emissions that cause warming. They talked about the increase in CO2 concentrations by 35% since the Industrial Revolution, and more than 1/3 of that added since 1980. And they talked about the physical phenomenon that once carbon or other greenhouse gas is emitted, it quickly mixes in the atmosphere and then remains present for a long time. And that was the fact setting that they were referring to. So here are just some pictures to make this concrete. The village, you can see how exposed it is. It's on the left, and it was on a little split of land, very, very low land. It was there because there are a lot of subsistence resources there. But the real reason that it's there in its current form is that in the early 20th century, a school was established there, and it essentially brought people there where they to settle so they could get their children educated. And there isn't any doubt that it's suffering from erosion and issues. You can see the picture on the right. There's no sea ice out there, and so they've got drums filled with sand and sandbags, and they're trying to address that issue. And so, as a factual matter, I think they found a case where you could point to climate change as being an immediate issue. What is the law? How did we deal with this? And this wasn't actually the case. Ultimately, went up to the Ninth Circuit on some preliminary issues like a political question argument and also a standing argument. But we had, I think, a nice analysis of causation. So the first test they needed to deal with was cause and fact. We also had sort of the proximate cause or the policy side of causation, but cause and fact was a much crisper and I think more specific way of addressing it. And so the test would be in this case and in many others, they had to show that the defendant's conduct was a substantial factor in producing the harm. Now, ordinarily, substantial factors is treated as requiring a but-for showing, but not in all cases. Importantly, in this case, if there's more than one actor that's involved in causing the harm, the general rule recognized by the restatement and also by Alaska law, which we were citing, says that the defendant's conduct must by itself be sufficient to cause the injury. In other words, you can't through this test say that someone was a substantial factor unless, even if there were a lot of things that were happening at the same time, at least their conduct was enough so it could have caused the harm by itself. Now, that's not a test that these parties could meet. I was part of the group representing the oil companies. There were 4 large international oil companies. Even if you aggregated all of our emissions, across the world, it was less than 4% of current emissions that could be tied to those companies. Of course, each one had a lesser share. But they were talking about emissions that had built up since the Industrial Revolution, with contaminants that would be in the air for more than a century. Our percentage was extremely small and couldn't possibly meet this general test. So, of course, the plaintiffs had a theory. They tried to find a solution to that, and what they cited were cases that were the joint liability pollution cases, as we came to discuss them. And an example of kind of a good, vivid example was the People versus Gold Rush Run Ditch and Mining Company, in which there were a bunch of miners out here in California during the gold rush, and they were just a beehive of activity in particular areas, and they were blasting away at canyon walls with water guns, and it just destroyed watersheds, and it caused a lot of property damage. And the court said, well, even though no one of these individuals could have caused the harm, collectively they did, and so we're going to allow a collective theory. And so we're going to treat everyone as jointly liable. And so that seemed like it was a theory that might work for them. But then as you think about it, it's got 2 insuperable problems. One of them was their theory would essentially make every person or business in the planet a potentially liable person for climate change, because all of us are generating carbon. All of us are adding to the anthropogenic, carbon emissions, or virtually all of us are. And so they didn't have a limiting principle. They basically said, well, their legal principle said everybody who contributed was going to be liable, and there was no cutoff. And the other one was, essentially, importantly from a judicial standpoint, this can apply really only where the claimants and the defendants can be joined together in the same lawsuit. And obviously there was no way that you could get all the claimants and all the defendants together in a single climate change lawsuit. So that theory didn't actually prove itself. And that's kind of an example of how you need to dig right. You need to find the area where they've got a soft spot and dig into it by pursuing the law, pursuing the facts, and figuring out how to make the case to the judge. I'll be brief in these remaining points, but in terms of preparing and arguing it, this is a point that Judge Kramer was making. There's less and less time for complex judges. They have enormous burdens, and quite simply, you want to make it as easy as you can for the judge to rule in your favor. Give them give them what they need to know in a simple way, but a way that's fair, where you really marshal your best facts up front. 2 important things I think that are very critical. You need to identify and pay special attention to the issues the judge is going to find troubling. Don't run away from them. Those are really important. Those are things that can prevent the judge from getting to the results you want. So you need to think about those and offer the judge the best possible explanation of why your position is correct. And also, whenever possible, it's really important to try to say not just our side is correct in the law, but it's the right thing to do, that there's a purpose behind it, a rationale. And I think if you do those things, you'll find much better results in motion. I'm going to not pursue these, but we got here a final thing, a checklist of motion ideas. Yeah.
Matt, before you move on to that point, I just wanted to ask Judge Kramer's reaction to your last points here about how you position this for the judge. I'm particularly curious, Judge Kramer, whether you have any advice for defense counsel on how best to communicate their potentially case-ending arguments to the court, and in a way to get as favorable a reception as possible.
I have advice to all counsel, because I'm the lady with the blindfold. So this applies to defense counsel and plaintiff's counsel. The idea of selecting a target, conducting discovery so that you can pin down the issues, and then presenting it to the judge is what you're taught in law school. And part of the idea is that it's going to be a surprise to the other side when you finally put your nuclear bomb together. But unfortunately, it's going to be a surprise to the judge, too. Another alternative is at the beginning of the case, you think out what are these case ending or major issues, and tell everybody, we want to focus on product identification first, Judge. We want to focus on causation. Then rather than conducting discovery, you talk to the judge about what I do all the time, which is get a case management order with what I call and what you guys call plaintiff fact sheets and defense fact sheets, where the facts that would otherwise come out in discovery are exchanged pursuant to a court order, not discovery. You end up, if you have a questionnaire that the plaintiffs have to fill out by court order that says, what makes you think this defendant's product caused your injury? And from a defense perspective, a fact sheet that says, what information do you have that your product did not cause this injury? You have an efficient, cost-effective exchange of information. The judge is already primed as to what this is all about, and it develops with the judge's participation so that when you show up with your motion, it's not a surprise. It's not 4 banker boxes that showed up and the judge goes, oh my God, what's in here? But rather it's what everybody expected was going to happen in the case anyway. And that to me is one of the most effective methods of setting up this motion practice where you have what you think are determinative issues. And the second thing I'm going to offer here is when you're writing your opus magnus here that tells the judge, see, we were right all along, there is no causation. You first on your word processor type the following. Here's the deal, colon. And then you write the whole rest of it using that tone. And then when you're done, strike out the here's the deal language. Actually, you can leave it in for me. But that's the focus. It's easy, Judge. We told you there was a problem from day one with product identification or causation, and here it is, right here. So that's my suggestion on this dispositive motion practice.
Thanks.
Oh, by the way, the right thing to do, that's good, but we don't get to do the right thing. We have to do the legal thing.
But I think most judges still like to do the right thing.
Well, they may like to. Yeah, that's right, but
I would endorse what you say, Judge Kramer. The only thing I think is I am a little concerned about. I think letting the judge know in advance is really valuable, and I love the idea of having the court require people on both sides to come up with the specific facts in an efficient way. I think that's great, but I do think you have to grapple with the ever-changing theories of the other side, and that's one reason why I said some of the things that I did.
Right. Well, that means you write the questionnaire. I mean, the fact sheets properly. What makes you think defendant X's product caused your injury? Now, that's pretty direct, and that one is a little bit hard to, after the motion comes in, to say, well, we now have a different idea. So it's all in the skill of writing the questions clearly and precisely. That's why the here's the deal thing is a good metaphor for the tone of this entire process.
And so then finally, we've got some ideas here, but I think we're out of time, so let me turn it back to you, Steve.
Sure. And let me just say we have a question on one of the topics that you've listed here, Matt, which is the preemption point. Someone's asked for a little bit more discussion of that point. The preemption, and I think in the pharmaceutical context in particular, the preemption is a subject which could easily occupy an entire program just on its own, and so we're not really going to be able to address it in any detail. But I can touch on a couple of points very quickly. I mean, I think at least in the pharmaceutical area, obviously the sort of signal event was the Wyeth versus Levine case, which held in the Supreme Court, which held that, of course, branded manufacturers, claims against branded manufacturers for failure to warn, strict liability claims were not preempted. Still left open potentially some avenues of argument, although those have not generally borne a lot of fruit yet. And then more recently, the Mensing case by the Supreme Court, which held that, on the other hand, that claims against failure to warn claims against generic manufacturers are preempted because of the sameness requirement that generic manufacturers are in their labeling. The more interesting, one of the interesting issues that's come out of that, and more recently, is whether claims against those generic manufacturers can be pursued on a failure to update theory. That is, can a plaintiff say that they failed, that the generic manufacturer failed timely to update their labeling after the branded manufacturing labeling was changed? And there's a split in the courts on that. I mean, just very recently, for example, the Sixth Circuit held that that those kinds of claims are not preempted. On the other hand, the Fifth Circuit went the other way. So this is something that's still developing. Supreme Court is going to be deciding probably in a matter of a few weeks the Bartlett case, which is an appeal from the First Circuit involving design defect claims against generic manufacturers and whether those are preempted. And there was a very interesting argument in the Supreme Court on that topic. And we'll see what the Supreme Court does probably in June. And the other issue that comes out of all of that is this question of innovator liability following the Conti decision in the California Court of Appeal, which held that the branded manufacturer could be held liable for failure to warn, even though the plaintiff had taken a generic drug. And so far, most of the other courts have not, around the country, have not followed that decision. But fairly recently, the Alabama Supreme Court, on a certified question, ruled that under Alabama law, there was a claim for misrepresentation there. And that's, I think, currently there's a motion to reconsider pending in the Alabama Supreme Court on that question. So there's a lot happening in that area. I can't really say more at this point without taking too much more time, but I will say that we have a number of publications on our website that address some of these preemption issues. And, of course, you're welcome to go to the site and see any of those you'd like. Also, we're happy, obviously, to take any questions offline that anybody might have, and even possibly to arrange for private briefings on some of these issues if there's particular interest.
Let me add something quickly here. If you have a subject matter jurisdiction point, raise it as soon as you can so you can get a resolution in the trial court and get it into the Court of Appeal before people waste too much money.
That's very good advice, Judge. Moving on, the next topic we wanted to talk about is sort of a key issue that involves resolving mass torts. It really is based on the very characteristic that really makes them mass torts, which is that they involve a lot of people. There are large numbers of plaintiffs. And in particular, how can we effectively deal with the volume of claims, and what steps can be taken to avoid being swamped by the sheer numbers of plaintiffs, or possibly to use what I'll call legal jujitsu to use those numbers to our advantage in some instances. And Bill Voth here in New York is going to lead the discussion on that point.
Yeah, the heading, disaggregating claims requiring individual proof, is kind of a mouthful, and it covers a very broad range of topics. And we're just going to try to highlight a few and perhaps some issues that may be new to folks. This obviously overlaps with the other issues because whether and to what extent claims can be aggregated or not, and whether and to what extent individual proof of every element is required, can bear heavily on case management, on motions, and on trials. And I guess the first point I just wanted to make, which may be obvious to everyone, is that aggregation is a key issue both to plaintiffs and defendants and certainly to the courts. And this comes in, I guess, several dimensions that the courts have recognized. One is that aggregation can really affect the risk and settlement position in calculus on both sides. Clearly, if there are large numbers of claims that are going to be resolved in one proceeding, particularly if individual proof, say, of causation is not required, that can really increase the defense's risk and may affect their settlement calculus. On the other hand, if there's no aggregation and the plaintiff has to prove every claimant's claim individually, then that likely will affect, almost certainly will affect its settlement view. Similarly, that decision will affect the time and money the plaintiff's counsel is willing to invest in the case, and it's seen its likely reward. And it's been recognized that aggregation can affect the outcome of the merits. I mean, for example, there's one well-known Fifth Circuit decision called Castano that states aggregation of claims makes it more likely that a defendant will be found liable and results in significantly higher damages awards. And it cites the Manual for Complex Litigation as sort of empirical support for that. So clearly, in addition to kind of the transactions costs, it can affect how the case comes out. And so with that, I just wanted to identify some claims aggregation devices. People tend to think about and talk a lot about class actions, and those are clearly very important. And the thesis I want to advance, perhaps be shot down, is that with the Supreme Court's decisions in such cases as the Comcast case, in the Walmart case, in the endgame case dealing with mass torts, it probably is becoming harder and harder for plaintiffs in mass torts, whether they're single accidents or multiple exposures, to get classes certified. It's always been difficult, but I think some of the appellate decisions out there are making it more difficult. And so at least I've seen plaintiffs who are innovative and creative use some other devices. One I've called for shorthand de facto mass joinder, which is essentially lots of individual claims that aren't formally certified as a class action, but get dealt with through case coordination as if they're one in large part, and with the view of trying to create settlement pressure. Another instance is governmental plaintiffs, cities and counties, for example, or state attorneys general, bringing suit on behalf of a lot of people, and whether they're asserting a claim on behalf of the government or not, asserting lots of individual claims as a single action. And that has the effect of aggregating the claims and sometimes having the benefit of favorable legal doctrines. A third example is third-party cost recovery actions. One example would be some insurers filed suits against tobacco companies, for example, seeking economic recovery, but essentially underlying that are the claims of various individual smokers. And each one of those devices has had, kind of mixed success, but plaintiffs' lawyers creatively have tried to use those to avoid issues, for example, of having to prove causation on an individual basis, which sometimes is proven fatal to efforts to certify classes. Another way that we're seeing in mass torts to try to aggregate claims and dispense with individual proof have been various legal theories, and I've listed a few here that we've seen. Rather than bringing a sort of a traditional product liability claim that requires identification of the product and individual causation proof, plaintiffs have tried a number of things. Public nuisance is one example we've seen quite a lot of, which by its nature is intended to be for invasion of a public right, and the legal requirements of that may not be quite so clear-cut as in product liability law, and so some plaintiffs have pursued those, particularly by having a governmental entity bring suit. Another example that comes up is an effort to avoid the problem of having to prove reliance in a fraud claim. which has often proved fatal to class actions. And so there have been a number of theories, such as fraud on the market or particular consumer product statutes, which don't require individual causation to avoid that problem. Another are collective liability theories, where the effort is to put an entire industry on trial. Which would go under various names. Market share is the one Matt mentioned, or sometimes conspiracy or concert of action. Again, an effort to avoid the need to prove individual causation. Something called presumed causation, which is a label of my invention. And the example I'm thinking about is where the claim of wrongdoing and injury is phrased in such a way that it seems natural there must have been causation. One example that we've seen is an effort to argue that a governmental statute or regulation has caused the injury. So every citizen is equally affected by it, so there's really no need for to have individual causation analysis. An example would be in some states have mandated that every child receive screening for blood leads to prevent lead poisoning before they go to school, and either the parents or the insurers have to pay some modest amount for that. And so the theory is that the defendant's wrongdoing caused the state legislature to enact this statute, and that's what caused the harm, and so you can presume causation. These kinds of theories have had mixed success, but they certainly are creative, and I think it may well be that folks will see more and more of them as time goes forward, particularly if class actions continue in the tort context to be fairly unfruitful. Another approach to try to aggregate claims, and particularly this happens quite a lot in the class context, is to repackage the relief as something that doesn't seem to require individual proof of causation in the way that a traditional personal injury claim does. We see many plaintiffs saying, I'm not really looking for personal injury, I am really looking for some economic injury. There's been some harm caused by a product that's caused me to spend money out of pocket. For example, I paid more for this hazardous product than I would have if it had not been hazardous. And that's a theory that's had some success. We've seen a lot of medical monitoring claims where the claim is that it's not really personal injury, it's going forward because of exposure. People need to be screened, and there's no individual variation. This has been a hotly contested area in class action law. Some courts have certified medical monitoring classes. Many have not. It tends to depend upon what the underlying state law requirements for medical monitoring are. And then just moving forward, I'd mentioned third-party cost recovery claims as a sort of a way to aggregate claims. We've also seen injunctive relief claims, which I would characterize as a defense lawyer as disguised damages claims. It's an effort to say, I'm really seeking injunctive relief, and so you ought to certify my class or not require me to prove individual causation because I'm asking for an injunction directed against the defendants to rather than damages. Sometimes when you really try to boil it down, it turns out it's an injunction, it's essentially an order to pay money, to say to fund an abatement program, an educational program. These are, as I say, very creative ideas, and sometimes they work and sometimes they don't. But it's sort of efforts to avoid individual proof and to aggregate claims. Before I get to defendant strategy, I would be interested, Judge Kramer, in sort of your observations and your experience upon the importance of aggregation and sort of where in the judicial process, particularly as a case manager, you try to see those decisions made or try to organize the case so the parties in the court know how the case is going to be litigated and know what kind of proof is going to be required.
Well, there's a administrative component of aggregation that you people never think of, which absolutely fascinates me. I regularly see mass tort cases with joined, that is, named multiple plaintiffs. The biggest one I've had was about 1,400 individual claimants on this happened to be a medical device. Each one allegedly had the device implanted in them, and each one suffered, supposedly. But it's one lawsuit, one filing fee. Defense filed one filing fee. So I took a look at that, and I said, well, this is interesting. Where will you form the line the morning of trial? And the plaintiff's lawyer looked at me like I was crazy and didn't understand. And I said, well, you're going to bring 1,400 people in for trial. I guess, they ought to line up so we don't have to waste time finding them. And long story short, the problem was, of course, we really needed 1,400 lawsuits. And from an administrative perspective, just the court system, taking a lawsuit and breaking it up into 1,400 separate lawsuits overwhelms our clerk's office. Although the filing fees, pro hoc vice fees, and complex litigation fees were massive, so we were greedily looking to get that money. From a defense perspective, that would mean each defendant would have to pay a separate filing fee, just like each individual plaintiff, and from a defense perspective, the amount was huge. I looked at this and I thought, what a great opportunity for case management, and we quickly put together a fact sheet on the key stuff regarding the device, and I said, okay, the facts are going to get exchanged, and you get 6 months to evaluate these cases. And those that survive the 6 months, that is, those that everybody thinks are viable cases that have to exist, each one has to be filed as a separate lawsuit. But during the 6 months, you can take the bad ones and settle them or dismiss them. And everybody loved that idea, and we ended up with several thousand of them going away. Still ended up with several thousand starting, but it's a case administrative thing, and it's a good opportunity. The problems you've identified here are good for case management and for the invisible hand showing up. The other thing that I see that is fascinating is statistical analysis and what different litigants are trying to do. If you want to do something funny in a case management conference, walk in and use the term regression analysis in front of the judge and watch the eyes glaze over. And very few of them are facile enough to just pretend like they're not surprised. And a lot of time and a lot of money is going to be spent on trying to aggregate damage theories or cost theories of some sort. And I think that might be the next horizon that we're going to spend a lot of appellate time dealing with.
Okay, thank you. I just wanted to talk a little bit, I say defendant strategy, but I think it really is broader than that. And I guess my main point would be to anticipate and don't react. That is, think about the question of aggregation from the outset, make it part of your case planning, have a plan, pick a target to move towards, and structure all of your thinking from the outset, from the first case management conference towards that. And I think it's important to have in mind and be able to tell the judge in a persuasive way early on about if this case has to go to trial, in the real world, how it will be tried. And this is why it's impractical. And at least I've found, whether it's in a class action certification context or otherwise, to be able to give the court real-world demonstrations with real proof of what the case is about and how it would have to be tried or concluded is really very important, because lawyers quite often on both sides talk in abstractions and make assertions about things and sometimes employ hyperbole that doesn't really have sort of the grounding in the facts of the case and the practical aspects of, can this enormous case be disposed of either on legal grounds or tried in some way that will actually lead to a resolution, before the end of time. And I think just as kind of a wrap up on this section, I just wanted to kind of pick some class action battlegrounds, which are just kind of a recap in a way of things we went over very quickly. The plaintiff tends to try to define or redefine the class to avoid problems of predominance, and they do this through picking a legal theory, some sort of causation theory that essentially presumes causation in a de facto way such that anybody would say, of course, that's right. Sometimes they will try to define a class for particular issues, which sounds like it makes sense, but in the courts, issues classes have been somewhat controversial, and the key really is whether is this an issue that can be separated out, and if you decide it, will it actually accomplish anything? And a lot of proposed issue classes have foundered because it couldn't satisfy those questions. Plaintiffs have tried to redefine the relief to avoid the problem of individual damages by the devices we've talked about. And on the defense side, I think the battlegrounds are stressing and explaining in a real, concrete, fact-based way why individual proof is needed on all of the elements, but particularly causation. And I guess the other suggestion I would have is the importance of persistence. This is an issue that needs to be dealt with and thought about at the outset of the litigation, but just because there's a temporary reversal doesn't mean you should give up. And without telling too many war stories, there was one instance where a class was certified on one of these presumed causation questions. We got into discovery. We had some focused discovery, and it illustrated that the assumption that the court had made in certifying the class was not really accurate empirically. And so once the court saw the record, there was a decertification. And there was some trepidation about going back to the court with that, but that's what the facts established. And so with that, I think,
So, Judge, if I could ask you to turn back to this question for a second, what are your thoughts on this sort of tension that's here between, on the one hand, the frequent defense side impulse to disaggregate the claims of plaintiffs in mass torts, as Bill suggested, and on the other hand, the plaintiff's typical desire to get all the claims resolved together as much as possible. How do you as a judge view that issue and address it?
I think Bill's point is outstanding, and I'm going to say something startling to all you people on the phone here. That class action is not an area of jurisprudence. It is a case administration tool, period, for use by the courts to deal with a whole lot of individual matters, perhaps in an aggregate way, period. And the way to deal with it from either side is to treat it as a case management tool. And not only, let's pick defense side because that's what was just articulated and that's what the slides show, not only point out what's wrong with what the other side wants to do, but what you have in mind instead. That second half of it is almost always missing in presentations. You hear, Judge, you can't possibly try all this as a class action because of the following matters. And I always say, okay, fine, so what do you want to do instead? If you treat this aggregate matter as something that is a practical problem from the judge's perspective, and it is, and you not just show what's wrong with what the other side wants to do, but how you propose to do this, you've got a much better chance of having the thing dealt with in the way you want to do it. I don't think
Judge,
yeah, go ahead.
I was just asking another question. I mean, the courts in this context often distinguish between mature torts, often cited as asbestos, and immature torts. In the former, there's sort of a judicial track record, there's sort of a sense of how the cases come out, versus immature torts where things are new, the science may not be settled. Have you sort of seen that division in the cases you've faced, and has that affected how you've managed those kinds of cases?
Yes, some of the, what I guess you would call immature torts, I'm not sure I like that term, it has too many implications. But when you're getting what seems to be a new thing, either new science or new problem that society hasn't experienced before or something, it's an opportunity for the court to not be dealt with, not have to deal with the baggage of what we've been doing in certain kinds of cases, and asbestos, unfortunately, is the poster child for this. I mean, one of the things that I noticed when I saw mass tort cases coming into the San Francisco court was I took a look at how we had dealt with the asbestos cases, for example, and I saw that we were inundated with motions for summary disposition on product identification within 30 or 60 days of trial, regularly. And I thought, well, how could we have that, and how do we avoid that? So what we try to do, and what you could do to help us, is to point out the problems that the mature torts have caused for the court system and suggest alternative ideas. That's where my regular procedure of exchanging information with questionnaires was born, because I thought the lawyers, for whatever reason, weren't focusing on product identification until you thought you were about to get a courtroom. And so we were inundated with all these motions for summary disposition on product identification. I thought, well, we should do all this stuff sooner. So what I think is that the newer cases are easier and more conducive to having a routinized way of at least administering them than the mature ones. Mature ones have had lots of problems. The court systems have been bogged down substantially. Now, that's not to say there aren't other examples of efficiencies, but you build off of those as well, only in a positive way.
Okay. Thanks, Your Honor. So let's move to the last section here, and at this point, hopefully, in your cases, the good ideas we've heard about and others have yielded some favorable results for you, at least from a defense perspective. That means the cases are dismissed or substantially resolved, or at the very least, the plaintiffs are discouraged. But of course, we know that doesn't always happen. It can't always happen. So suddenly trial is looming. And what do you do now? Well, you don't need to despair like our friend here. First, this shouldn't be the first time you've thought about it, or to have thought about what you're going to do at trial. The tendency sometimes, I think, has been to think about trials tomorrow, sort of like Scarlett O'Hara, thinking about it tomorrow, and then suddenly trial is looming. Sort of as a looming disaster or some kind of torture chamber that you just hope to avoid. And of course, we all know bad things can happen at trial, and bad things do happen at trial, and that can't always be avoided. But you can also see trials as a tool for resolving mass torts as advantageously as possible if you're not able to do it through some of these other mechanisms. And there are some approaches out there actually that may help you manage or at least reduce some of the risks of going to trial, which we thought we'd talk about. And just if there's a theme I think that's run through today, it's it's all of these things we've been talking about are things you should be thinking about from day one, really, including trials, including what are the trials going to look like, what are the issues going to be at trial, what are going to be likely your strongest and weakest issues at trials, how would you like to have those presented at trial in the way that's most advantageous to you. And you should start laying the groundwork for all of that with the court, and Judge Kramer mentioned that. You should, if you have some ideas about how the cases might get resolved or certain key issues you think the court ought to focus on before other issues, which might be case ending, at least think about getting those out early. And there are also some tactical issues that Matt referred to. So, but you should be definitely thinking about these issues from the very beginning and laying the groundwork in your motions and your discovery and your dealings with the court from the very first. And there's a series of factors, obviously, you want to think about. I don't need to run through them all. I mean, the key ones I think are here. A couple I'll point out. Your adversaries, and one of the things to think about, just as a practical matter, are there some adversaries you'd rather face before other adversaries? Economics really means are these, what's it going to cost? And how much can you take, or how much are you willing to take? How much can the other side take? One thing that's not mentioned here is the type of damages that's involved. It probably should have been mentioned. That is, are the economic damages primarily, or are we talking about personal injury damages? That may also have an effect on the kind of trial you want to see. So some of the approaches that I just want to touch on in the time that's remaining are here. Bellwether trials that Judge Kramer's already made a reference to. Bifurcation of issues and various variations on bifurcation. Something I'll call issue trials. And then finally, something that's not really a trial at all, but I'll refer to as screening trials and describe that in a minute. Bellwether trials, as Judge Kramer mentioned, are one way that you can address these mass tort cases, and is a commonly used device in many courts. Initially, early on, at least historically, some courts considered making the bellwether trials binding in some fashion on the other cases that would be following them. But generally, that approach was met with some significant skepticism, and probably well-founded skepticism, because of the potential binding effect on parties who would not be present at the trial. And one of the cases that was sort of seminal in this area was the Cimino case by the Fifth Circuit back in '98, which essentially raised due process and some Seventh Amendment concerns about binding subsequent parties to the results of the bellwether. So now today, more likely, if not exclusively, bellwethers are used really for purposes of sort of informing the parties and giving them a reality check about the nature of their cases so that they can make choices going forward about how to proceed. The primary benefits, I guess, that people see from bellwether trials are that when it does give people a reality check, the parties a reality check on their respective strengths and weaknesses, they get to see some number of cases go to trial first so they can get an assessment of how strong or weak their positions are. And the thought is, at least, that this may, at the very least, facilitate the ability of the parties to possibly settle the other cases in the group. Another factor here is that sometimes bellwether trials can avoid the expense of discovery, at least of the non-selected cases, because in some bellwether situations, discovery doesn't proceed on many of the cases. It only proceeds on the cases that are selected as the bellwethers, and so the others, at least for a while, may be parked out of active discovery, which may or may not be to your advantage tactically. And it also actually may result in potentially case-ending motions. There was just some recent decisions in New Jersey State Court in the Nuvering cases just this week, where a judge granted summary judgment in a group of cases that have been selected as bellwethers, and obviously that now creates all sorts of issues, at least for the plaintiffs, about what's going to happen with the remainder of their cases. There are some significant issues, though, with bellwethers that need to be addressed up front, and I've listed the primary ones, I think, here. The key ones being, first you've got to be able to select a truly representative group of cases that both sides recognize as such. Otherwise, there's little point to it. If the results, if neither side or one of the sides in the litigation is not going to view the results as really representative, then they may not get very much out of it. And so that means often you have to start early in the process of developing a bellwether strategy by doing selected discovery and sufficient discovery in order to identify that group of representative cases, as well as not just in the facts of the individual cases, but also to try to determine what are the different factors or the different criteria you're going to use for determining what's representative. Timing, product use, injury, a variety of things that you can use to decide what's a representative sample. And then you have to have a selection process which prevents the parties from gaming the system. Again, which really relates to the first point, if the parties can game the selection of the bellwethers, at least one party is not going to view the results as valid and may not get much out of it. I'll go through this very quickly, but typically in the selection of bellwethers, the process is a sort of two-step process. One is you select a pool of potential bellwether cases where discovery will proceed, and then you select the trial cases from that pool after there's been some degree of discovery of that pool, and that does require that you have enough, a little bit of a horse and cart problem or chicken and egg problem. You have to have enough discovery initially for the parties to be able to intelligently pick the discovery pool. So, for example, the sorts of fact sheets that Judge Kramer was referring to can be very helpful in that regard, giving the defendants and certainly forcing the plaintiffs to think about the key factors, the key information about plaintiffs that may give them the opportunity to select the discovery pool. You have to be able to define the key characteristics, as I mentioned, that you're going to use to define the pool, whether it's the time of exposure, the place of exposure, the injury that someone's claiming, the type of exposures that they might have encountered, and so on. And that you need enough information to be able to make those sorts of judgments. Then typically, once you have a group of potential group for discovery, you have to decide whether you're going to use a system for essentially hand-picking the pool, that is, letting the parties or the court or in some fashion decide which of that group, which of the population you're going to select for the pool. Or in some cases you might do it randomly. The Manual on Complex Litigation has talked about using random selection procedures, but I think, at least from what I can gather, most courts tend to prefer using some kind of hand selection where the parties themselves select the pool for discovery. And then finally, once you've had that initial discovery, you have to have some process for selecting the trial group, and that often is a process where the parties each submit their candidates, if you will. There might be a process by which each side gets a certain number of strikes against the other side's selection, and maybe the court will make the final decisions about how to proceed or which cases will go to trial, or perhaps there'll be a process where there's alternating picks and that sort of thing. So you have to have all of these processes worked out, and each of them has a certain strategic and tactical considerations needs to be thought about as you go through that process. The other issue you have to think about in terms of bellwethers is what I refer to here as the lexicon issue, at least in MDL, federal MDL proceedings, and I've given the site for the case, the lexicon case that this comes from. Essentially, the Supreme Court held that in an MDL, federal MDL, cases which are transferred to the MDL from other venues cannot be tried in the MDL court without the consent of all the parties who are going to be involved. Otherwise, the MDL court has no choice but to send the case back to the original venue, the original transfer court for trial. And that obviously can hinder the ability, at least in an MDL, for a court to assemble a representative set of bellwethers. Another approach, besides bellwethers, is what I refer to as bifurcation. And typically, at least in federal courts, this relies on Rule 42B of the federal rules and their state analogs, which essentially allow the courts to separately try different issues or claims in a case. And the classic formulation is you try the liability issues before causation damages. So in other words, you first try the question: did the defendants do something wrong? Did they violate a duty? Were they negligent? And the jury will decide that issue, hear the evidence, decide that issue, render a verdict. If their verdict is favorable to the plaintiffs, then you go on to the question: and did that conduct hurt the plaintiff? And if so, what's the damages? That's the classic formulation of bifurcation. It's usually not always in front of the same jury. And if you go to a different jury, you run into some potential issues about the Seventh Amendment you have to be conscious of. And this can be done on a case-by-case basis, or it can even be done in aggregated cases, although it gets much more complicated there. And sometimes you'll see a variation where it's trifurcation, effectively three separate trials, where, let's say, liability is tried first, then causation. Did the conduct cause the injury to the plaintiff? And then finally, if there's a yes to that, what's the damages? One particular variation on this that I've encountered, I've had a fair amount of experience with, and is actually pretty interesting, is something that's called reverse bifurcation, which sounds a little bit like a cardiac surgery of some kind, but it's actually just that. It's really just flipping the order of the trial, so that you try causation and damages first, and then you try liability. So in other words, first you decide, did the defendant's drug or product harm the plaintiff? And if so, what's the damage? And only if there's a plaintiff's verdict do you move on to the next subject, which is liability. And there's sometimes punitive damages that are a separate issue as well. And this is a technique that was really pioneered, I think, in the Philadelphia Court of Common Pleas in the asbestos litigation, where it was used for many years. But interestingly enough, that court has recently, just about a year ago, suspended their reverse bifurcation process in those cases, and pretty much every case in that court. Among other reasons, I think there was at least a sense from defendants in asbestos litigation that the process was actually less favorable and ended up with higher verdicts against defendants because of the concern that causation, the liability issues are really not there's not much surprise about what's going to happen in liability issues, but the causation and damages issues are quite disfavorable, unfavorable to plaintiffs and to defendants rather, and they were afraid that it was causing them to have higher verdicts. On the other hand, in other cases like the diet drug litigation, the fen-phen litigation, the defense found it quite useful, I think, to have reverse bifurcation, because those were cases where liability was fairly well understood, and the real question was, did the drug cause any actual injury to these plaintiffs? And often the juries found that there were very small or no damages. We're about to come to the end of our time, and so I'm going to just skip the sections on issue trials and screening trials, but you'll see here that there are some other techniques that can be used. Screening trials in particular are simply really panels of experts, either individual experts, panels or individual experts who are appointed under the rules to provide guidance to the court on complex scientific issues, which can often be very helpful in screening out cases that have no scientific basis. Since we're up with our time, obviously you'll be able to take a look at these slides when you get them after the program. But I'm going to conclude the program now. And obviously, if any questions remain, please don't hesitate to contact us at the email addresses you'll see here on the last slide. As I mentioned earlier, the audio recording for the program will be posted to our website 1 week from today. And we'll also send you an email with a link to the slides and supporting materials and the evaluation. And I want to thank everybody for participating today. Judge Kramer, thank you for being here. We appreciated your attendance and wish everyone the best. Thank you. It presents its own unique challenges. And as far as that goes, I'd sort of like to start with a judicial perspective, Judge Kramer. As a trial judge who's presided over many mass tort cases, what particular challenges do you see in mass torts from your seat on the bench?
Well, the subtitle of this program is All's Well That Ends Well, and I'm actually participating in a slightly different webinar than the rest of you gentlemen here. The title or the subtitle of my program is called All's Well That Ends, period. And the point of all that is that from a judicial perspective, the most important characteristic of mass torts, be it the kind where a single event has allegedly harmed a bunch of people, or recurring events of a similar nature allegedly harmed a bunch of people, is case management. Case management is the most important focus from a judicial perspective. And there are many reasons for that. The first and perhaps most important is that, as you all know from reading your newspapers, judicial resources are getting scarcer and scarcer. And if we're basically called upon to do the same thing many times, it doesn't take long to figure out we better be able to save judicial resources by being efficient in how we cause the same thing to be resolved many times. And that is certainly true when all of the mass tort claims, be they separate cases or not, are in the
unique challenges for a variety of reasons, unlike many other cases. We'll just touch on those quickly. Obviously, just the size of mass torts. They're mass torts for a reason. They're large. There are many plaintiffs involved, and they typically involve the extraordinary amount of expense and time. Obviously, the number of parties involved are often a challenge in themselves, especially when you have parties from approaching the issue from different perspectives. For example, you might have manufacturers, you might have distributors, you might have, in a pharmaceutical case, doctors. On the plaintiff side, you may have a variety of different classes or types of plaintiffs. The discovery is often extremely broad and wide-ranging, often multinational. Mass torts also present unique problems involving collateral estoppel and res judicata issues, especially for defendants. And so those are issues that you have to keep your eye on, obviously. Mass torts are also complicated by the fact that you frequently have multiple counsel representing all these different parties, many of whom will have separate interests and maybe competing interests, especially often on the plaintiff side. Also, of course, you have cases where you're dealing with many different jurisdictions and courts, state courts, federal courts, multiple jurisdictions overlapping in many cases, and obviously that presents certain challenges as well. And then just the sheer ability to manage the cases is and keep them moving. First, let me make some introductions for our panelists. We're actually coming to you bi-coastally today, but from our New York office and from our San Francisco office. In San Francisco, we're joined by Judge Richard Kramer, who is a judge of the San Francisco Superior Court, who was appointed there by Governor Pete Wilson in December of 1996. He presided over felony trials for 5 years and then joined the General Civil Trial Department. Most notably, from about 2002 until just the beginning of this year, Judge Kramer was assigned to the San Francisco Superior Court Complex Litigation Department, where I think it's safe to say he was renowned for his effective management of innumerable complex cases, including many mass torts. He also served as a justice in the Appellate Division of the Superior Court for 3 years and as a justice pro tem in the Court of Appeal. And he's also an adjunct professor of law at the University of California, Hastings College of Law, just with all the extra spare time he must have. But we welcome Judge Kramer today. With Judge Kramer in San Francisco is my partner, Matt Hartney, who's actually from the Los Angeles office. And Matt has a long experience in a variety of cases, including many mass torts. He's involved in lawsuits and regulatory proceedings involving, as well, antitrust, environmental cases, RICO, products liability, and federal securities laws. And now here in New York, I'm joined here by Bill Voth, my partner. Bill is also a very experienced product liability lawyer and has a long experience with mass torts, consumer and product liability litigation involving a whole variety of things, including medical monitoring claims, class actions, government cost recovery suits, and the like. And I am actually from the Washington, D.C. office and am a trial lawyer and mass torts lawyer myself, primarily involved in litigating pharmaceutical mass torts. Unfortunately, Jen Dubas, who was on our program, who is from Endo Pharmaceuticals, is not able to join us today due to some pressing business matters, and we're sorry she could not join us today. We thought we'd start by focusing today on primarily on some of the ways that mass torts can be brought to a successful conclusion other than by settlement. And that is, we'll be talking about some of the strategies and techniques that can be used to get to or achieve what we call the endgame. And for purposes of today's discussion, we're going to use the term mass torts to mean both, single events with many victims, like an explosion, for example, and mass exposure events, that is, for example, where drugs or chemicals have been, or people have been exposed to drugs or chemicals, often for long periods of time. So we're going to be talking about mass torts in both senses. And as I'm sure all of you know, mass torts present.
Porter.
Thank you. Good morning or good afternoon, as the case may be, and welcome to our mass torts litigation webinar. Which is the fourth in our series on mass torts, and it's the final in the series. If you were not able to attend any of the earlier ones and would like to do so, or at least to view them, feel free to go to our website at www.arnoldporter.com, and if you click on our practice and select product liability litigation, you'll be able to find those prior sessions in the events category. Just a couple of mechanical issues. For today's webinar, the lines have been muted, but if you ever need assistance during the call, just press *0 on your phone and the conference coordinator will be able to help you. Also, we have a chat feature, as many of you may know, in the WebEx program, which allows you to ask questions during the program. If you want to send us a question, we will be viewing it here, and while time constraints might make it impossible for us to answer all of the questions, we'll certainly try to answer what we can. And, of course, feel free to contact us after the program if you want to follow up on any other questions. Finally, this event is being recorded and will be posted on our Arnold & Porter website, where it'll be available for public viewing afterwards. And shortly after the program, we'll send you a short link with an evaluation form and presentation materials from today, so you'll have those for yourselves. With that, let's get started.